few days of session, I'm opening we're opening the meeting of the Joint Committee on Marijuana Legalization for February 22nd. And today we are going to have two work sessions. One is going to be a work session on Senate Bill 1601, which makes some technical fixes that we need to make to bills that have already passed substantively. We'll talk about that in a minute. And then we'll move on to Senate Bill 1598, for which we have a couple of amendments that we'll talk about and move and work the bills. And the goal is, because you may know that we're in the final several days of session, and it's important to work bills so that we can move them across both chambers before the end of the session. Our goal is to work both bills today. So I'm going to start by opening a work session on Senate Bill 1601. I'm going to invite our committee administrator to describe the bill, and then I'll add some additional language. Just be aware that it's a technical fix bill. Actually, I'll open the work session on Senate Bill 1601 and turn it over to our committee administrator, Adam Crawford, who will explain why we're in a situation of revisiting a couple of provisions that have already been in substantive bills that we've passed.
Madam Chair, members of the committee, Senate Bill 1651 has a minimal revenue impact. 1601, has a minimal revenue impact and a minimal fiscal impact. The provisions contained therein were predominantly found in House Bill 4014 as well as Senate Bill 1511. Those provisions are: they exempt marijuana sold to an Oregon Health Authority registered cardholder from taxation. It allows all marijuana establishments to deduct business expenses allowable under Section 280E of the Internal Revenue Code when filing a state tax return. It prohibits a retailer from discounting marijuana items or offering a marijuana item for free if sale of an item is made in conjunction with the retail sale of another item. It takes effect on the 91st day after the 78th Assembly adjourns silent. It is that final provision that caused some consternation. As our Senate colleagues are aware, with any bill that otherwise adjusts to revenue, it cannot take effect immediately under constitutional provisions. We have been received some legal opinions that say the passage of 1511 and 4014, while legal, would be put on firmer ground with some of the amendments that will be heard to Senate Bill 1598 as well as Senate Bill 1601.
So I'm going to add a couple of words to that to make sure people in the room understand that there are not new substantive provisions in these bills, but 1511 and 4014 have something called an emergency clause on them, which means that they would take effect right away. But you can't have an emergency clause on something related to revenue. So even though those bills don't raise taxes in any way, they just deal with patients having the right to purchase tax-free, or medical businesses being able to have the same kind of 280E deductions that we authorize for adult use businesses. The fact that there's an emergency clause on each of those bills creates some trickiness, and in order to protect all the other provisions in those good bills from not having to wait 91 days, to take effect, we're taking those two provisions that are relating to revenue, and we're putting them in their own bill, 1601, which will not have an emergency clause on it. So it's kind of it's a technical thing. It's necessary, and we want to make sure we get this right. So since they're not new substantive provisions, we're not planning to have a public hearing on it. We're just explaining to you what's going on, and I would welcome a motion from my vice chair.
Madam Chair, I move Senate Bill 1601 to the floor with a to-pass recommendation.
All right. Vice Chair Wilson moves Senate Bill 1601 to the floor with a do-pass recommendation. Is there any discussion? Seeing none, the clerk will call the roll.
Senator Byer.
Excused.
Jeff Buckey.
Aye.
Senator Cruz.
Aye.
Representative Hall.
Aye.
Representative Olson.
Aye.
Co-Vice Chair Ferrioli.
Aye.
Co-Vice Chair Wilson.
Aye.
Co-Vice Chair Krasomski.
Aye.
Co-Chair Burdick.
Aye.
Co-Chair Lyman.
Aye. All right, the motion passes. Okay, the motion passes and the bill is sent to the floor. And who would you like to have carry that bill on the Senate side? House side, I'd like to have, if we could have Representative Helm, Representative Olson carry it, because they actually were the original bringers forward of patients buy tax-free. Would you like to co-carry that, guys? Okay, yes.
I'll make you do it.
Okay, good, teamwork. All right, so we're closing the public hearing on Senate Bill 1601. Sorry, closing the work session on 1601, and we're going to open a work session on Senate Bill 1598. We have several amendments to 1598, one of which is called a gut and stuff amendment, which is kind of an amalgamation of a lot of the ideas people have been bringing forward that replaces the current body of the bill. And I'm going to invite our committee administrator to describe that amendment, which is the -25 first.
Madam Chair, members of the committee, the -25 amendment has a fiscal impact statement and a minimal revenue impact statement. It is comprised primarily of the -1 amendments regarding fingerprints, the -3 amendments from Representative Buckley regarding the transfer of marijuana to and from a processor, the -4 amendments broadening the exemption that would allow a marijuana grow site with at least one grower first registered with OHA prior to January 1st, 2015 to not have to receive a land use compatibility statement prior to licensure. The -5 amendments declaring marijuana as a farm crop for research certificate holders. The -6 amendments requiring an individual who works for a marijuana producer, processor, wholesaler, or retailer to have a valid worker permit issued by OLCC, and that it becomes operative July 1st, 2016. The -8 amendments allowing a person responsible for a marijuana grow site to delegate the reporting of tracking information to OHA to another OHA registered grower at the same grow site address. Also the -10 amendments in a modified form allowing a nonprofit medical marijuana dispensary to be operated. It strips out some of the provisions relating to a mobile operating unit contained within the -10s. It also includes the -12 amendments requiring the OHA to solicit for proposals for the purpose of choosing one or more entities to conduct public health and consumer safety research relating to marijuana. As I mentioned, this does have a fiscal impact statement and a minimal revenue impact statement.
Okay, so that is the -25 amendment. What I propose to do today is go through some of the amendments one by one, and then at the end of that conversation, seek a motion to take the bill to the floor with a do pass recommendation. But Mr. Vice Chair, do you have a motion?
Madam Chair, I'm sorry, I should have mentioned this to you in advance. Would it be possible to take the -25 and the -15 amendment, because we have a member missing who's involved in very important business and needs to hear the discussion on the other amendments, but he doesn't need to hear the discussion on these two because these have been thoroughly.
She's calling for the question on 25 right now.
Oh, I'm sorry. I thought you said we were going to do them all at once. Okay.
No, thank you.
I'm sorry.
Thank you, Senator Fuzzy.
Sorry for the interruption, committee.
All right. Please, yes.
Madam Chair, I move to adopt the -25 amendments dated February 19th, 2016.
Vice Chair Wilson moves to adopt the -25 amendment to Senate Bill 1598. Is there any discussion?
There was one question that I wanted to get clarification. I know the -1s have been incorporated in there, but it's modified. Adam, I don't know if you know the particulars as to what was changed from the -1 version that was put into the -25. I got word back that there's some modification.
Madam Chair, Senator Przansky, I can look into that and get back to you.
I think Representative Buckley had a question that asked me about it, but didn't have the answer.
I also have a question, Madam Chair, not the fiscal that Adam mentioned. I'm not sure where it is on the list. I need to have it on the -25 amendment.
Madam Chair, Representative Buckley, my understanding, we can have Teresa McHugh come up to explain it further, but my understanding is there's roughly $350,000 worth of additional expenditures.
Senator Przanski, in response to your question about changes in Senate Bill 1598 from the dash ones, this is what I think is the change. We added following the discussion last public hearing work session last week, we incorporated in a number of the amendments that were freestanding amendments that Mr. Crawford had read aloud to be part of a kind of a consolidated, integrated bill. And I believe this is an accurate description of the sort of top line of the categories that got added. The existing agricultural buildings, grandfathering in certain opaque structures.
My question was really specifically the dash ones that we had originally dealt with fingerprinting. And my understanding that was key to have that work done so the background checks could be done. What I understood, and my quick question to LC was what amendments did we pick up in the 25s that were freestanding? And what I got back was the dash one, but it says fingerprinting modified. And I looked at it and I didn't see anything that looked like we had changed from dash one language to what went into the 25s as the dash one. And I was just wondering if there was something else that we picked up on the fingerprinting part only.
I'm not aware of anything that's been picked up on the fingerprinting.
Okay. I'll pass.
Okay, great. So that was one aspect of discussion on the motion, which is to add the dash 25 amendments to Senate Bill 1598. Any other discussion? All right. And if we could please call for the roll.
Senator Byer.
Excused.
Representative Buckley.
Aye.
Senator Cruz. Representative Bennett.
Aye.
Representative Olson.
Aye.
Co-Vice Chair Ferrioli.
Aye.
Co-Vice Chair Wilson.
Aye.
Co-Vice Chair Przanski.
Aye.
Co-Chair Burden.
Aye.
Co-Chair Langman.
Aye. The motion passes. All right. And now the dash 25s are adopted in Senate Bill 1598. And now we will consider dash 15 amendment into Senate Bill 1598. Mr. Crawford, if you could just quickly summarize that, that would be great.
Madam Chair, members of the committee, the dash 15 specify that OHA may inspect a marijuana grow site of a person designated to produce marijuana by an OHA registered cardholder, becomes operative March 1st, 2016.
All right. May I have a motion on that,
Yes, Madam Chair, I move to adopt the dash 15 amendments to Senate Bill 1598 dated February 18, 2016.
please? Vice Chair Wilson moves to adopt the dash 15 amendments into Senate Bill 1598. Is there any discussion?
Just a clarification.
Yes.
Just to make sure, this amendment, just trying to make sure I got this straight in my head. It clears that OHA may or may not inspect medical home grows. I'm trying to. Prohibits. It prohibits. Yes. I just want to clarify that.
Other discussion on the dash 15 amendment? If not, let's please call the roll.
Senator Byer.
Excused.
Representative Buckley.
Aye.
Senator Cruz. Representative Cohen.
Aye.
Representative Olson.
Aye.
Co-Vice Chair Ferrioli.
Aye.
Co-Vice Chair Wilson.
Aye.
Co-Vice Chair Przanski.
Aye.
Co-Chair Burden.
Aye.
Co-Chair Langman.
Aye. All right, the dash 15 amendments to Senate Bill 1598 are adopted. And now we will move on to consideration of, would you like to take a brief recess, Senator Burdick, or shall we move on to consideration of additional amendments?
We've got 4 people here. Do you want to try a straw vote? Maybe Olson and Meyer gets here. How do you want to do this? He's in a important meeting right now. I've asked him to come. You have to be on the floor, your side at 2:30.
2:30.
So it's up to you.
I'd like to have Senator Meyer here so we can hear why I'm doing this role. Not have that opportunity to sit down and talk.
Okay, if we can have a 5-minute recess, I will go sit down somewhere else.
Okay. The committee is going to take a 5-minute recess. To recap, we've got 2 amendments have been adopted into the bill, the -25s and the -15s, and we are now going to consider additional suggested amendments before we seek a motion to move the bill as amended to the floor. So are there additional amendments that people would like to identify?
Yes, Madam Co-Chair, I have 3 or 4 that I would like to consider.
All right.
So I will start with, let me just, -23s and -24s are the ones that deal with residency requirement as it pertains to production license. The 22s would be one that would be just outright prohibiting someone that didn't have 2 years. I understand from yourself, Madam Co-Chair, that you think that we should allow for more people to come in, so I will make a motion to move the -23s instead of the -22s. -23s is a residency requirement would be for production only, but it does in fact allow for those individuals who don't meet the residency to actually come in and have a vertical license. The vertical license would allow for those individuals to be able to grow within the limits that are set for current grow levels for Oregonian producers, with the exception that if an individual, whatever they grow, they can only sell within their own structure. In other words, they would not be able to flood the market or put stuff into the general market. They would have to be vertical licensed, meaning they'd have to have, the production would have to be going either into their own dispensaries, recreational sales, or into their own processing for that same purpose, and it'd have to be sold within their own structure. They would not be able to take added value product and put it into the general circulation. This is based on my belief as to what we've heard throughout the session during the 2015 testimony. Overwhelmingly shows that we have 3 to 5 times the amount of production level that we need to provide for the medical grow, medical side, as well as the recreational side of use of product. And since we already have 3 to 5 times already the amount already being produced in the state, based on the testimony we heard during House Bill 3400 and the other bills we considered last session, it only seems appropriate that we consider what the ramifications are if we allow for open-ended additional production. It would, in fact, I believe, put us in direct violation of the Cole Memo, where the Cole Memo states that we're not supposed to be enhancing drug cartel activities and stuff seeping outside of the state. Each of you should have at your desk that I have put on there, and it went on hold us this late morning, a memo that came in from our legislative council, our mayor, dated today, that basically goes through the issues that some individuals have had a concern that if we try to do some type of regulation in this industry at this stage, that we would be in violation of the interstate commerce or the privileges and immunity clauses of the state constitution, or the Constitution of the U.S. Clearly, the memo shows and demonstrates that that is not the case. That we do in fact have the ability to regulate, because this is not an item that is in commerce in the nation. You cannot have interstate commerce between any states on a substance that is illegal under federal law. And so this would in fact give us the opportunity to monitor and measure how much more additional production we need. It would in fact allow for those who do not meet, again, the residency levels now, to actually be able to produce for their own operations that we've already provided for, in the removing of the residency on the processing, on the license, all the other licenses except for all the production has been removed. But I'm asking for that to go back in place. So that's the basis for this particular one. Again, it's based on the testimony we had, and my hope and goal that we would be able to ensure the federal government that we're not somehow circumventing the 8 points that are listed in the Cole Memo and somehow assisting the diversion. I should put on the record as well as that the more product you bring into the general commerce of the state, you're going to cause the price to continue to drop. the lower the price goes, you're going to get into a position that we're trying to incentivize individuals who have not been in a regulated system to stay out of the system, and they will be in direct violation of the code memo, which will mean our state will as well. Thank you.
Thank you. Senator Brzezinski moves to adopt the -23 amendments into Senate Bill 1598. Is there any discussion? Representative Buckley.
Thank you, Madam Co-Chair. And Senator Brzezinski, thank you for the amendment. I strongly support it for all the reasons that you listed. It makes total sense to me. It also seems to be a kind of creative compromise by offering the vertical licensure idea and sunsetting this amendment in 2020, if that's my understanding of the amendment. And I think it's a compromise. It's the chance to do a step-by-step process into the new industry that's being developed to see what happens in terms of the quantity of production. I think it's a cautious way to go. I'd also just like to make a comparison to, we do, for instance, in-state tuition and out-of-state tuition in Oregon's universities. And the idea behind an out-of-state tuition is that someone who's coming in is actually viewed slightly different than someone who grew up here, someone who has been resident here. The person who's been resident here has helped to build the infrastructure and build the state to the point where the arena is that they're entering into. And so we make that distinction for out-of-state students, and I think we could make that distinction for out-of-state growers as well. Originally, we're trying to make that distinction for investors and providers of other products in the industry. We've compromised down from that to focus simply on the production of marijuana, and I think this is a compromise that's worthy of support. Thank you, Madam Chair.
Thank you. Is there further discussion? Senator Byer.
Thank you, Madam Chair. I respect the position that my colleague has offered, but I find that I don't agree with that. I think that people have spoken that they wanted to legalize marijuana. They've done that. The best way to control that is through an open market-based system. I don't know why we would treat it differently than any other product. We've had lots of discussions in this committee about how the right to farm legislation applies, and said that this marijuana should be able to grow the same way that other products do. And I think the same thing applies to the sale of it. I think we just treat it like any other drug or any other product, and people invest in it, and if the market drives the price down, generally we consider that to be a good thing.
Thank you. Senator Brzezinski, looks like you had a hand up.
I did, thank you. I guess I just want to respond, and I'm not sure if Senator Byer understands, we actually have taken the right to farm away from this particular commodity. And some of the other amendments, the -25s, actually now allows for counties and cities to have regulations on this commodity, even though it has been identified as a farm product and a commodity. It explicitly calls out in the -25s that those two areas are now, or that area has now been circumvented, and local governments can in fact regulate marijuana, cannabis, separate and distinct from any other farm product.
Thank you. I think I see the representative Buckley has a hand up. I would say I want to note that the -25s actually extend right to farm protection to medical cannabis, and also to I don't know what section it is, but to OLCC, to research produced cannabis. No, I'm sorry, I think that's a misstatement. But in any event, I know the Farm Bureau, which is carefully protective of right to farm uses, is comfortable with the delineation that we have set forth, because cannabis is a Schedule I controlled substance. So I don't completely agree with your characterization, but I will defer to my colleague, Representative Buckley.
Sure, Senator Brzezinski, and she'll comment. I just want to respond to Senator Byer. If marijuana is able to be exported, if this was not a closed system within the state of Oregon, I would agree with you completely. I would say let the free market decide. Because we have a closed system, and the amount of marijuana that's produced has to go through that system, I share Senator Brzezinski's concern that the only other avenue for marijuana produced would be illegal exports outside the state. So again, I think it's a prudent step to take to monitor the amount of production we're doing, as long as it stays a closed system. If the federal government decides to deschedule and possibly export Oregon marijuana, I'd be in full agreement of not having residency.
Okay, so I know that you have a few additional amendments that you're hoping to bring forward, Senator Kozanski. The House has to be back on the floor close to 2:30. Would you like to make another point, or shall we call for the roll now?
No, I like to.
Okay, please go ahead.
And so just to say, Madam Co-Chair, that you brought, if you look at page 3 of the -25 under section 4, it clearly carves out, and I already put on record, yes, it's considered a farm commodity, but we've had exceptions. So if you look on line 29, it explicitly says that local governments, meaning the counties and the cities, can in fact have the ability to have ordinances imposed on the regulations of these businesses. So that is something that we are carving out. And I had my conversation with the Farm Bureau, and they acknowledged that that's exactly what they're doing, but they were trying to do that to accommodate some individuals on this committee. Thank you. I'll call the question.
Okay, thank you. Let's take the roll then, please. That is on the motion to add the -23 amendments to Senate Bill 1598.
Senator Byers,
No?
Representative Buckley,
Aye.
Senator Cruz, Representative Helm,
Aye.
Representative Olson,
No.
Co-Vice Chair Ferrioli,
No.
Co-Vice Chair Wilson,
No.
Co-Vice Chair Kozlowski,
Aye.
Co-Chair Burden,
No.
Co-Chair Lyman.
No. All right, the motion fails, and the -23s are not adopted into Senate Bill 1598. Are there additional suggestions for amendments to Senate Bill 1598?
Now, Madam Chair, I'll move the -24s.
All right, Senator Kozanski moves to adopt the -24 amendments to Senate Bill 1598. Is there any discussion?
Yes. And the -24s, what that actually will do is hold the local governments again to the points that we made a decision during the 2015 session. Specifically, what we stated was that we were not going to have a distance requirement between medical versus recreational sites, and that they could be seated, situated side by side if they wanted to. That the only distance requirement was going to be 1,000 feet between similar types, rec to rec or med to med. And what we do know is that from the testimony this last week, there are numerous cities that have actually established new distances that in violation of the intent of what we were put forward as to our goal to not have a distance between those two different facilities. Thank you.
Thank you. Is there any further discussion on the motion to adopt the -24 amendments into Senate Bill 1598?
Madam Chair,
Yes, sir.
just as a question, I guess I would direct to Adam or Senator Kozanski. Did we not do a reasonable man test for time, place, and manner? That they had to be reasonable.
Madam Chair, Senator Ferrioli, that was my understanding.
And that would give potentially a cause of action to folks who thought they were not treated reasonably. Thank you, that's my observation.
Yeah, that's correct.
Is there any further discussion on the -24 amendments? Senator Byron?
Yeah. I'm not completely sure what your amendment is. Can you explain it?
What the amendment does, it says that we, when we were meeting during the 2015 session, this committee, and then I believe based on the votes that we had on each of the floors, basically said that we were going to set a policy that says that a recreational facility, meaning retail outlet, and a medical dispensary would not have any arbitrary distance requirement between them, that they would be able to be seated even side by side. If you remember, that was when we were looking at potentially needing to maintain the integrity, the separateness of the programs, ensuring that the medical program was not going to be violated, as the terms of Measure 91 said we're not supposed to make changes. What I do know for a fact is that the city of Portland has actually instituted, based on some of the advocates going to them at the local level, and basically now they have a 1,000-foot requirement between any facility, no matter if it's rec to rec or rec to med. And so they are basically, from what I thought we were intending to do, have circumvented the policy of the state by now putting an arbitrary number of 1,000 feet in between a medical and a recreational facility. We heard this last week from some of the people that gave us testimony that Portland was not the only city to do that, that other cities have started to follow Portland's lead. And so I thought that we had made that clear enough that everyone that was part of this process, including the stakeholders that were here, would honor what we as a state has said was the policy between the distances. And apparently that's not it. So I'm coming back now. We have this time to actually say, this is what we said in 2015, this is what we meant, and now that portion is now into the statutes.
Senator Burdick has a comment.
Thank you, Madam Chair. The intent, and we did have a discussion on this, was to allow local governments to locate them next to each other without violating the 1,000-foot state law. It did not require them to do that, and I would oppose any motion to require them to site things together. This should be a local decision. But what we did in 3400 is we made it clear that if they want to have one next to the other, they won't be violating state law, but we did not require them to do that.
Okay. I don't see any further hands up. Oh, Senator Black.
Anyway, we have, at least at the start, allowed medical dispensaries to sell recreational as well. Is this in any way to limit that going forward?
It's not my understanding, President, that I'm going to make a comment and then Senator Brzezinski has a comment. My recollection of what we were doing last session is that we were very intentionally allowing local communities to impose reasonable time, place, and manner restrictions in the effort to encourage local communities to want to cite these new legal businesses within their jurisdictions. The reasonableness of time, place, and manner restrictions is absolutely subject to challenge if it's unreasonable, and so I agree with Senator Ferrioli's point on that issue. So Senator Brzezinski, please go ahead.
No, I'll pass.
Okay.
I'll call the question.
All right. If the clerk could please take the roll, that'd be great. If you could speak a little more loudly, that would help me. Thank you.
Senator Byer.
Yes.
Senator Buckley.
Yes.
Senator Cruz. Representative Helm.
No.
Representative Olson.
No.
Co-Vice Chair Ferrioli.
No.
Co-Vice Chair Wilson.
Yes.
Co-Vice Chair Brzezinski.
Aye.
Co-Chair Burdick.
No.
Co-Chair Leininger.
No. So the motion fails.
Madam Chair, I'll move the dash 26.
All right. Senator Brzezinski moves the dash 26 amendments be adopted into Senate Bill 1598. Is there any discussion?
Yes, the dash 26, what it would do is would require that the fees that are collected currently in the OMMP program stay within the program. What we have is a current policy of seeing money being diverted from those fees that are collected by OHA and using that money to provide for services in the OHA umbrella services, but not exclusively for OMMP. I understand that there have been agreements that were made previously as to the need for utilizing some of that money for other services, but I also understand that based on the dash 26, this would not go into effect until July 1, 2017, when the co-chairs of Ways and Means will be able to make the adjustments that are currently being relied on, and they can actually straighten this out to the point where we would actually have truth in fee collection, and it would stay within the program and not be diverted to supplement. The reason I bring this forward is we've heard time and time again from patients about how much more it's costing them to get their cards and to maintain their ability to get their medicine. And it seems to me a travesty that we have at least $5 million at this point that could stay in the program, that could in fact make certain patients aren't priced out of being able to get their medicine.
Thank you, Senator Brzezinski. Representative Buckley had a comment.
Yes, thank you, Madam Chair. I support this amendment. As Senator Brzezinski mentioned, in 2011, in the midst of the financial crisis we were facing, was a deal that was made for the 11-13 budget. We have not been able to find a way to unravel it. This, I think, would give a chance for legislation to say that we need to unravel it. and make sure that the fee levels go for the marijuana program. The other programs that the communities are going for now are essential programs or in health authority. If we can in the next rebalance OHA, do it if there is the ability to make that shift prior to July 1st, 2017, I would be very supportive of that as well. This would give us a chance to kind of redo and back in place the payment of fees for the service offered.
So for the discussion, Senator Byer and then Co-Chair Burdick.
Thank you, Madam Chair. I actually think I support this amendment largely because under the theory, the difference between taxes and fees, taxes are general revenue coming in that can be used as the legislature deems appropriate. Fees are supposed to be just adequate enough to cover the cost of operating the program and should not be a source of revenue to support other things. So I would have a different argument if we were talking about a marijuana tax. If we're talking about a fee, Senator Brzezinski is correct.
Co-Chair Burdick.
And thank you, Madam Chair. I support the intent of this amendment. I do think that in a short session, when we're talking about a budget adjustment like this within our bill, that part makes me nervous. I think it's a broader discussion. I'd like the discussion to include, other aspects of how the OHA spends money on marijuana. That's too detailed a discussion to have here. Given the timeline of when this amendment takes place, I would welcome further discussion in the 2017 session to make sure, because it was an emergency measure. I was around in 2011. It was a very bleak time, so I can understand how something like this could happen. It is time for it to end, but I don't support this amendment in this bill, but I do support the idea behind it.
Thank you, Co-Chair Burdick. I agree that this is an interesting conversation, but we are very close to the end of a short session, and it feels late in the day to be having this conversation when we've been trying to work the bill and work a lot of elements of this bill, essentially since we got out of the last session. So I support the idea of us having this conversation and potentially memorializing it in legislation that could be passed in 2017, but I don't have enough information about this bill to this amendment to be able to support it right now. Senator Byer.
Thank you, Madam Chair. It's a little bit comical. I understand the concerns, but note that we have the co-chair Ways and Means sitting on the panel supporting this amendment.
All right.
Call the question.
Okay, so let's call the roll on the issue of whether to adopt into Senate Bill 1598 the Dash 26 amendment.
Senator Byer.
Yes.
Representative Buckley.
Yes.
Senator Cruz.
No.
Representative Holmes.
No.
Representative Olson.
No.
Co-Vice Chair Ferrioli.
No.
Co-Vice Chair Wilson.
Aye.
Co-Vice Chair Brzezinski.
Aye.
Co-Chair Burdick.
No.
Co-Chair Langenese.
No. Motion fails. Are there additional motions that people would like to bring forward?
Yeah, I'd like to bring the dash 28.
Senator Brzezinski moves to adopt the Dash 28 amendments into Senate Bill 1598. Is there any discussion?
Yes, Madam Co-Chair, what I want to do is on the dash 28, this is trying to give us some parity and uniformity, I guess, to what has happened in other states as it pertains to the dosage that is allowed for and serving size allowed for both recreational and for medical products. The Oregon Health Authority has put out a proposal to change their rules after they heard of a pretty large backlash that's dated February 15th. By looking at that, the current levels that they are proposing to modify, they would have a maximum for on the recreational side of edibles of 5 milligrams for a serving, per serving, and then the maximum on the container of 50 milligrams. This is half of what is the numbers that are both in Colorado State as well as Washington State. So my amendment to Dash 28 would in fact give us parity and uniformity to the other two states as to what is already happening in those states. And clearly knowing that we're engaging and bringing people into the state to actually start their production here. Most of them already have established roots in either Colorado or Washington State. This would give them the actual uniformity to be able to make product that's similar to the same portions that they have. Regarding on the medical side, the proposed rules under OHA would be limited on edibles for medical patients of 100 milligrams. We've heard so much testimony throughout this hearing process, this session as well as last session, that that is not an adequate minimum dose to have, because it would take some individuals maybe 10 candy bars to get to 1,000. This measure, the dash 28s, would in fact put in a, for edibles on the medical side, a 1,000 milligrams, which would be much more in line with what we've heard from the testimony, what some patients need. Does not mean that all of the medical products can be made at 1,000 milligrams, because manufacturers now are doing different variances, but it would in fact give some uniformity, and it would not change any of the other proposed rules by OHA for their new proposed rules. Thank you.
Thank you. Is there additional discussion, Representative Buckley?
At the risk of jinxing Senator Brzezinski again, I support this amendment.
Is there further discussion? Senator Dwyer?
I'm reluctant for the legislature to get involved in dealing with dosages at all. It seems like it most appropriately is left to the professionals. Well, I mean, I agree with them. That's what we hire them to do.
Senator Israeli, yes.
Madam Chair, I think the issue is very troubling to me personally, because I agree with the idea that the legislature is the last place we should be setting pharmaceutical doses. But we have neglected an opportunity to bring in folks from hospice and other folks that would have much more personal insight into the amount of palliative care that people need who are having these problems. I don't know if doubling the dose is a good idea or a bad idea. I respect the concept that we should be taking this issue up and studying it more carefully. It doesn't matter to me what the dosages are in Washington or Colorado, because we're going to do it right here. But I would submit to you that this is an issue that needs a lot more attention. I don't see that it is a reasonable thing to require people to consume mass quantities of product to reach a palatable dose. That argument, I think, is a good argument. But I'm not sure where the right line is between the concern about child safety and the issue of palliative care for people that have a medical need. On the recreational side, I'm much less concerned with the dosage on the recreational side. People will simply do what people will do, and that, notwithstanding the fact that they might have to open several packages, they will continue to medicate or recreate until they reach the desired internal state of mind. So I'm very sympathetic to the idea that we need to do more work on being reasonable in the context of palliative care. I'm not at all interested in messing around with dosages in the rooms.
Okay. I don't see further hands up. I would note that in Senate Bill 1511, in Section 15, we made an effort to urge OHA to consider the medicinal uses to which medical marijuana is put when they set the dosage level. So that was our effort to signal, hey, don't set these dosages too low if we're trying to help people treat conditions while at the same time avoiding prescribing actual numbers and statute. It's a challenging issue. I am not able to vote yes on this amendment, but I think it definitely incorporates some important themes. So with that, Senator.
Further pontification. At least, or not at least, in groundbreaking legislation, Oregonians have said we need more research, and we want to see research done, and we want to support research, notwithstanding a 150-year ban on research. So I think that research is going to provide these answers at some point, I hope by 2017, when we're back in session.
Great. Thank you. Representative Wilson.
Yeah, Madam Chair, I've gone back and forth in this discussion at least twice, taking two different positions. absolutely believe that, but I also know the children are going to get into this. It's just going to happen. And I think it's probably no surprise to expect poison control centers from heretofore are going to get a lot more calls. So it boils down to an issue where I know that in caring for those under OMMP, they do need higher dosages. I absolutely believe that. But I'm just trying to match that with what I know is going to happen with children getting a hold of high-dose products. I'd like to telegraph my move, but I want somebody else to pontificate for a little bit more before I make my decision.
No, that was
The reality is, we've had the OMMP program for 15, 16 years. We have not heard this outbreak of all these kids getting into loopholes of medicine. I do agree that you are going to potentially see an issue on the recreational side, just because they're probably not the education. Many of the individuals that came before us actually talked about how they educate their children as to this is medicine, you stay away from it. And we've not seen the poison control thing going off the charts for the last 15 years under the OMMP program. And I believe, based on what we've had on, and that's why the measure here is just basically giving thresholds. It's not saying as to what's going to be required at the production side. It just allows for these as maximum. So if someone wants to have in the medical side a product that does give 1,000 milligrams or a product that does 500 milligrams, they can do that. And it actually puts a threshold where it's not going to be over the top, much greater than that. And for the recreational side, having a limitation of 100 milligrams, which is what 2 other states have, I feel that that's a number that we now have been testing for 2 years in those 2 states, and it doesn't seem like that is out of sync with what others have had, and that's why I chose those numbers to be learning from their experiences and not waiting necessarily for additional research on this side. At least this is a starting point, and we can continue having this discussion. Thank you.
Thank you. Should I speak again or should I? All right, let's go ahead and call the roll, please. This is, let me just tee it up first. It's as to the question of whether we should adopt the Dash 28 amendments in Senate Bill 1598.
Senator Meyer.
No.
Representative Dudley.
Yes.
Senator Cruz.
No.
Representative Collins.
Yes.
Representative Olson.
Aye.
Co-Vice Chair Gurriel.
No.
Co-Vice Chair Wilson.
Aye.
Co-Vice Chair Kozlowski.
Aye.
Co-Chair Burdick. No. Co-Chair Leininger.
No. The motion fails.
Excuse me, Madam Chair, did they call on you?
I got it.
So that motion fails as well. I know that the House is, we are asked to be back on the floor right around now. I want to be respectful of additional amendments. Are there any additional amendments? Okay. So I'd like a motion regarding whether to move the Senate Bill 1598 as amended to the floor.
Madam Chair, I move that Senate Bill 1598 be moved to the floor as amended with a due pass recommendation.
Okay. Vice Chair Wilson moves Senate Bill 1598 as amended to the floor with a due pass recommendation. Is there any discussion? Senator Kozlowski.
Thank you, Madam Co-Chair. As much as I'd like to have had the amendments that I brought forward, part of the bill, because I do believe that they will give us more certainty and understanding and allow for continuity throughout this process, I will be supporting the motion because there are so many other parts that I also agree with. I hope that we will in fact be able to look at some of these amendments and suggestions and ideas in the short fashion, because I do believe it will help us get further on the road and having some relief for medical patients specifically as it pertains to fees, as well as ensuring that there's dosage size and to bring to accommodate individual patients' needs.
Thank you. Additional discussion? Representative Tom.
Thank you, Madam Co-Chair. The core of this bill had to do with how we're going to treat cannabis as a land use on our And I think is a very important point to make, that the exception that we've made to the right to farm laws in ORS 30 are extraordinarily narrow, and they apply only to this particular kind of plant because it is viewed to be illegal in most other states. This does not open up the right to farm statutes to other incursions for other impacts such as odor, noise, dust, etc. This is a very particular crop, as folks in the audience very well know. It deserves some careful treatment, and because of that, we're allowing this very narrow exception to allow counties to impose some reasonable regulations on its location, and I have to stress again, reasonable. It is not reasonable to impose restrictions on this crop that are significantly different than similar crops would be. And I think we're seeing across the state now that some jurisdictions that have experimented with the idea of, for example, excessively large setbacks have pulled back from that after listening to our proceedings, and I think they're moving in the right direction. So I hope that we see that counties will continue to be constructive in adopting reasonable regulations, and we won't have to revisit this again in the future. Thank you.
Clerk call the roll, please.
Senator Meyer.
Yes.
Representative Buckley.
Yes.
Senator Cruz.
Yes.
Representative Hall.
Yes.
Representative Olson.
Aye.
Co-Vice Chair Burioli. Co-Vice Chair Wilson.
Aye.
Co-Vice Chair Kozlowski.
Aye.
Co-Chair Burdick.
Aye.
Co-Chair Leininger.
Aye. Motion passes. So we will have Senate Bill 1598 go to the floor. On the House side, I'd love to have Representative Coleman, Representative Buckley carry Senate Bill 1598. Does that work for you?
Madam Co-Chair, I would suggest that you should carry the most of the because Lightning carried it.
All right, we'll have that conversation later. But that's great. Great news, Senator Burdick.
Thank you, Madam Chair. I will sign up as a carrier now and work with my committee to see who would like it.
So everyone, this may be the last meeting of the Joint Committee on Marijuana Legalization, formerly known as the Joint Committee on Measure 91 Implementation. I want to thank everyone who's come to these meetings and given us your input and helped us shape a lot of work that we've done this session. I think together we've tried to do some stuff that will be helpful to the community. I want to thank the members of our committee who have been tremendous to work with, and note that you did all agree to stand here and have a photo taken for our post-session reminiscing. But I also want to turn it over to my co-chair, Senator Burdick, who's been tremendous to work with and whose help and insights I've really appreciated. Senator Burdick.
Thank you, Madam Chair. And I just want everyone to know that the heavy lifting in this pre-session and even during the session has been done by my co-chair here. She has worked tirelessly on the substance of these bills, has taken the lead on a number of the difficult issues, and I just want to commend you publicly for your work on that, and for the rest of the committee as well. And there are a lot of people out there in the audience who have actually contributed majorly to this package of bills that we have out of the committee. I feel like we've moved forward in a way that I think has been consciously, very conscious, but very ambitious to establish a successful program. And these, I think the guidance that we're providing here to the OLCC and the OHA will make a real difference in having a successful program.
Thank you. And thank you very much to Adam Crawford, who's been a great committee administrator. And with that, we'll close the meeting.
I'd like to make an announcement for those that are in the room. Our Judiciary Committee is going to be coming back in here as soon as we conclude the room. We have one bill that we need to pass out before 3 o'clock. So if we can clear the room and have the celebration outside, that'd be great.